In India, religious freedom is fundamental right. But is the conversion also fundamental right? Especially when we look at it when it has been done through illegal means, pressure, force. This does not remain limited to legality or illegality. It directly brings in the question of national security. What do you think? Because this question has directly been raised to Supreme Court, where forced religious conversions have been petitioned to be made equivalent to terrorist acts. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session, we are going to look at the constitutional dimensions, legal dimensions, especially around religious conversions, understand why Supreme Court is going to talk about the Tata Consultancy Service Nashik case and what was exactly in the case that it became a national news across this week. So let us begin with understanding that what exactly has been taken up by Supreme Court. Now when we are looking at it, so let us break it down. So basically TCS Nashik case, which is ongoing, I am going to break that down further, but in that very regard, a petition has been filed in Supreme Court of India. Now before we move ahead to understand that why this petition matters and what it says, let us discuss the TCS Nashik case, why it is doing rounds and why religious conversion has been brought to light because of this. So a case has emerged at TCS Nashik which not only involves sexual harassment, it involves mental intimidation and also religious coercion. And the problematic part here is that it was not individual based, a whole group was being intimidated, coerced and harassed. As of now, the key allegations are coming from 9+ women who are the victims in this situation, and the religious coercion is not about just pressurizing to convert to a certain religion, but also derogatory remarks about Hindu religion and forced participation in religious practice. Now the problematic part here is that this was happening in a corporate structure which was present, and it was being facilitated through a managerial level. As of now, what police has highlighted that yes, the allegations are right, there was a proper organized group, a racket was operating of the accused employees, and they were actually trying to work towards religious conversion, the forced religious conversion, and in the same regards, multiple FIRs have already been put up and a special investigation team has been set up which is further looking into this whole matter. Now this matter has come to fore and this clearly highlights there is convergence of the corporate structure which is leading to harassment, coercion, and at the same time it is also resulting in religious freedom violations. So when we are talking about this scenario, this whole scenario has reached Supreme Court and this has been already attached with an ongoing case. So there was a suo moto case that was picked up by Supreme Court. So when we talk about suo moto cases, these are the cases that Supreme Court takes on its own accord, on its own. So this case was going on and it was on conversions itself. So this petition has been filed in this case that was already ongoing. Now what this petition is for? This petition is saying that there needs to be a proper national framework, especially against forced conversions, and also that conversion, religious conversion, forced ones, should be declared as terrorist activities. Furthermore, establishment of special fast-track courts should happen so as to ensure that the threat organized conversion groups are playing towards national security, that can be addressed. So when we look at the heading that we started with, we can clearly understand that this petition is talking about the fact that how these forceful conversions are a serious threat to sovereignty, secularism, democracy and liberty, and multiple other fundamentals of our constitution. And if we want to address this, we need to take it as seriously as and that is why it should be labelled as a terrorist act, and a national framework should be made to address it. Now, when we have fairly understood that what exactly is going on, this is where it becomes important to look into and understand that what does our constitution say about religious freedom, and do we have Supreme Court judgments or any legal framework for religious conversions. So, when we are talking about religious freedom, yes, this has a direct place, direct link in our constitution. Article 25, which is a fundamental right, talks about freedom to profess, practice and propagate religion. But restrictions are present there. It is subject to public order, morality and health. So, two important insights we need to clearly take in from here. When it says propagate, it does not mean at all convert by force. And these restrictions also show that this fundamental right is also not absolute. Furthermore, Article 26 is also present, which talks about that how religious affairs needs to be managed. The key principle here is that yes, you have the right to propagate, but there is no right to forcibly convert. Then we further have Article 27 and also Article 28. Article 27 talks about no compulsion to pay taxes, especially when we are talking about for promotion of religion, and Article 28 talks about freedom from religious instruction, especially in state institutions. So, you can see that as a combination of these four fundamental rights, how religious freedom has been put out there in constitution and how it has been clarified. But even after such clarity, we do have cases of religious conversions which is also allowed. So, if we talk about at the national level, there is no uniform framework that talks about illegal religious conversions or forced religious conversions, but in multiple states there is law which addresses, and they have already enacted freedom of religion acts. For example, Uttar Pradesh has enacted. Multiple other states do have a act against especially forced religious conversions. What is the common provision which you will see? You will see that the conversion through force, fraud or inducement is prohibited. If at all this act is present, this legislation is present, it makes sure there is a provision that the prior declaration to authorities is important, and if anybody is found doing the prohibited conversion, the coercive conversion, then they would be punished through what? Imprisonment as well as fines. Now, in this context, when we get to see there is absence of a law at central level, it also leads to multiple scope in many states where there is not present. Apart from that, it also leads to ambiguity. No clarity is present. And in a situation where this is being used as a tool, and we know it is a threat to our national security, this central law, which is not present as of now, becomes rather more important, and this is exactly what the petition is asking for. So, Supreme Court's answer to it, the judgment to it will matter a lot, because recently Supreme Court has already asked the union government to look into it and come with a proper framework. And this is not the first time that Supreme Court will be speaking of it. Multiple times already Supreme Court has talked about it. For example, we have seen in Revest Analysis versus State of Madhya Pradesh case 1977. Back then it was declared that no fundamental right to convert others is present. The fundamental right is only for propagation, and that does not mean forced conversion. We also have Sarla Mudgal versus Union of India 1995. The conversion cannot be misused for marriage. Supreme Court has clarified 30 years back. We have another one, Lata Singh versus State of UP of 2006. Where Supreme Court clearly declared that you can marry, you have the right to marry person of your choice, but they did not legitimize forced conversion. The recent one we have Safin Jahan versus Ashokan. The right to choose religion is part of personal liberty which comes through Article 21, and that cannot be compromised. So all in all, Supreme Court has very clearly established through multiple judgments, there are more, where we get to see voluntary conversion, if it is happening, it is protected under fundamental rights, but if it is forced, then it is violation of fundamental rights and it becomes illegal. Now let us move towards conclusion, and first let us talk about issues that are being clearly raised from this situation. So when we are talking about issues here, the first thing that comes to light is the fact that how workplace regulation has failed here. Corporate governance has lapsed. HR accountability is in great question. Apart from that, this is where we get to see intersection of rights, because when I was talking about religious freedom, we have discussed Article 25, but as of now, Article 21, that you cannot be forcibly convert, it is about personal liberty. We also get to see that this case has highlighted that when we are talking about definitions, there is huge ambiguity around it. That what does it mean by inducement? Is it an economic inducement, social inducement? What are the examples that can be included? Because a wide variety of meanings can be inferred. And it raises a very important legal issue as well, where the misuse, yes, it is present, but there are genuine cases as well. And this is where the genuine cases might not be protected, they might land in problem. Now yes, these are the issues lying in front of us, but what about the main one which was raised in the petition with which we started our conversation about national security? So when we look at national security, as the petition clearly claims that organized conversions are nothing but engineering and altering the demography, and it possibly might have also foreign funding links. So that is why this petition is asking to classify this as a terrorist activity and then bring it under the anti-terror framework, because there is no coercive religious, anti-coercive religious forced conversion framework as of now. So yes, this is a concern for national security, but we have to also think about how, if we bring it in the same framework of terrorism, this will expand national security discourse clearly into civil liberties as well. And that is problematic in itself. So what should be the way forward? The way forward should be starting with clear definitions of coercion in law, and most importantly a central law. Then strengthen workplace ethics, grievances systems, and ensure that the regulation is appropriate. Apart from that, it is also very important when the issue is this or this, it is important to balance both of these. What are your thoughts on this? Let me know in the comment section. That was all from my side. I'll be leaving you here with the prelims practice question because we have discussed this in detail. I hope you are able to answer that. Let me know the answer in the comment section. Thank you so much.